Good afternoon and welcome to today's webinar on COVID-19 learnings from the UK. If you're an HR practitioner or a lawyer, you may feel like us that the law surrounding this issue is ever developing. We've always referred to the UK for guidance on interpretation of statutes and legislature, and for this reason we thought it relevant to invite two colleagues to discuss the South African position in comparison to the position in the UK. Before I introduce my colleagues, I'd like to remind you that any questions can be sent to cdh@events@cdhlegal.com. The first speaker is from the UK. Mr. Makbool Javaid is a director at Access HR Consulting, a UK and South African-based HR consultancy. He was a former partner at DLA Piper and is currently a partner at Simons, Murad and Button. He's also a UN investigator and training, and he'll be taking us through learnings from the UK first. We'll then be handing over to someone that's familiar to most of you, Advocate Feroze Boda. Advocate Boda was called to the Johannesburg Bar in 1996 and appointed as a silk in 2015, and he'll be taking us through the COVID-19 directives issued by the Department of Health with reference to the workplace specifically. He'll also be touching on very relevant topics, such as employees who are refusing to work, as this has become a very prevalent topic in the past 2 weeks. Without further delay, I hand over to Makbool.
Well, thank you very much, Anli, and good afternoon to everyone. It's a pleasure and honor to participate in this webinar. I think that the sort of beginning point to note is that it's what we will learn from this, I think, is that we need to have a joined up approach which involves HR, legal, and communication function within the business, because the issues will cross over all those particular areas, and it is important that we are able to ensure that there is a joined up approach, as I say. So if we look at the first slide, having been a sort of partner in a global firm for so many years, one of the issues that came up was the fact that we need to have a process whereby our policies are linked in with the training that we do and the application when problems arise. And also there are reputational management issues. So that is why Axis came about, is a putting under one roof all those different issues. So you can see, looking at policies, if there are investigations, mediation, etc. Next slide, please. And the other areas, and this is important for you as well, is that when things go wrong, we need to look at where we are going to be vulnerable, the high risk areas. Those will be with senior executives involving dismissals and particularly discrimination issues. And that's why at Axis we look at training and consultation in order to ensure that there is a joined up approach within the business. Next slide, please. And again. So what I want to do is to set the scene, really. In the UK, we've had, according to government statistics, 41,000 deaths, nearly 300,000 infections. That's had a massive effect on the economy. The GDP reduction is 11.5% in the UK. In Spain, it is 11.1%, Italy 11.3%, France 11.4%, and the US is 7.3%. Unemployment in the UK has gone up by 10%. Consumer spending is down 9.5%, and investment is down 12.6%. So there's been a big hit on business and the economy generally. At the moment, the government is talking about opening up schools, but there's a resistance from unions, and businesses are looking to open up, and next week more retail businesses will be open. And I think that there's a lesson there for us in that the approach we take has to be tailored to our specific circumstances. So that's the macro picture. on the micro side, the impact has been greater in certain sectors as compared to others. So it will not surprise you to know that hospitality, leisure and travel have been far greatly affected than other areas, as has advertising and retail. So the government's approach was to try to avoid what we call redundancies to retrenchments. And therefore, a job retention scheme was put in place, which essentially meant that the government would pay 80% of the salary of employees to avoid retrenchment, plus national insurance and pension contributions. But that was capped at a figure of £2,500 per month. And it was up to the employer to top up the remaining 20%. And also, employees were asked to take salary cuts. Senior executives in particular were asked to voluntarily agree to take cuts. The position was that, obviously, as you know, with contractual entitlements, these had to be negotiated by way of agreement, and by and large the figures show that a combination of accessing the furlough scheme and also staff voluntarily agreeing to take pay cuts, many businesses are able to survive for now. The pay cuts were around, and 80% was used as a benchmark. Now that we're looking to come back, the government is reducing the support that's provided. So as you can see on the slide, from July, employers will be permitted to allow employees to come back to work part-time. They're still on furlough, so they can work, and if they work, they get full pay. When they're not working, the government will still support them with 80% of their salary in the same way. From August, the pension contributions, the national insurance, when they're not working, will have to be paid by employers. In September, the contribution will be reduced from 80% to 70%, and in October, it will be reduced to 60%. In all these cases, the employer will have to make up the salary up to 80%, and then further still if they wish to do so. So you can see it's about easing people back into work, providing businesses with that financial support. Next slide. So what we want to cover are the issues and insights before reopening, how we reopen, and other issues to consider, and data protection. Next slide. I think the starting point, and people obviously are very worried, are very concerned about returning to work. As I say, with 40,000 deaths, there's a lot of anxiety and fear. And the starting point, therefore, is to look at what are your obligations as an employer. In the UK, we have a health and safety regime in the same way that you have in South Africa, and an employer is obliged, as far as reasonably practicable, to protect health, safety and welfare at work. And if we're honest with ourselves, many HR practitioners don't really get involved in health and safety issues. This is left to specialists. Some people argue that up until now, as far as HR concerned, it's been a tick box exercise, particularly for those sectors that are not involve hazardous work environments. It's not a big issue. However, I think that will need to change because the requirement is that we need to ensure that we are complying with our obligation to provide a safe system of work. And what is important is that the steps we take are tailored to our workplace. It's not a one-size-fits-all approach. and it is very important that you take that away from this webinar, that you need to look at your specific circumstances. Also, it's not simply about creating the environment, giving the instructions, it's about implementation. It is your responsibility to ensure that whatever measures you take are implemented. And this is borne out by the fact that the government has issued 8 guides. So different sectors will have different issues and different approaches. And you need to be aware that your sector will have a different approach to another. So trying to get a template from another organization is not necessarily going to work. So in the UK, the guidance is not law, and therefore, if an employer complies with that guidance, it doesn't necessarily mean that they won't have any claims against them or problems when it comes to health and safety. So risk assessment is extremely important. You need to carry that out. And what we have found is that you need to identify where the risks are, and you then need to create remedies or solutions to that. And we all know that in our work environment, there are different sort of categories or different areas. So even within our workplace, there will be different requirements depending, if it's in the admin, if you have a warehouse, if you have an area where the public have access to. So it will require a different approach. So it's very essential to have a fact-specific approach depending on your different environments. The position remains in the UK that the government says work from home is still the priority. If you can work from home, you should work from home. If you cannot, then you should come to work. So you can imagine that signal that is sent to most staff is that they should be working from home in the main. And therefore employers, and we'll look at this later on, and I know Feroze will touch on it as well, is what do you do in this climate if there is a resistance to returning? As far as the risk assessment is concerned, and you have specific regulations, in the UK, there is no need to publish that risk assessment. You publish the results if you have more than 50 employees, but I think it would be sensible for employers to publish the outcomes internally. You will have to consult, as in the UK, trade union and health and safety representatives. And you will have to make out a case as to why people need to come back to work, because as I say, the overarching advice at the moment is that people should work from home when they can. Now, another cautionary aspect that you need to bear in mind is that we need to be guided by that risk assessment, and it will identify the risks, and then we take appropriate action. Do not expend resources in buying expensive equipment or personal protective equipment, because it may not be necessary. You have to look at your environment, have to see what is required and how to do it. So we need to have trust and engagement with staff. The consultation exercise is vital. And when you come to the consultation with trade unions, there is little point in coming empty-handed. So you need to do preparatory work beforehand, carry out a survey, see what it is that your requirements are, what do staff want, what is the mood like, because if you go to that consultation and you don't have any options, or you haven't worked out what the solutions are, then it's going to be very difficult, because the experience in the UK is that the unions are rightly going to require very strenuous efforts to be made by you to provide that protective environment. And so the government has said schools should open, but the teachers' unions have said it is not safe to go back. So do your homework, look at the solutions, set out the options. So when you're in that consultation, you've thought about it. And as I say, you know, we have technology, carry out surveys. However, get the mood of your staff. What is it that is needed? What do they want? And then create a solution so that when you're consulting, you have some options and it's not just empty-handed. Next slide. So there are many solutions that have been proposed. Before I get on to that, we also have to bear in mind the mental health impact. You know, working from home, people are in isolation, they don't have that team bonding that usually goes on, and therefore there is research indicating that people, you know, have anxiety and issues, and we need to be mindful of that. So if you have the facility to provide staff with access to support counselling, and then that should be made available. If it's not available, then it may be something you want to think about as to how you can allow staff to be able to speak to a service where their anxiety and issues can be dealt with. So what are the solutions? Now, they, as I say, involve having staggered shift patterns, reducing meetings and having staggered break times, and obviously the hygiene measures. And you know, I could list those out for the next 30 minutes, but I'm not going to do that because we've seen you know, the use of hand sanitizers, mask wearing, people in some retailers handing out masks to people when they come into the building, having perspex screens at tills. So I think that you need to look at, you know, what is the minimum staff numbers that you need. Maybe look at additional entry and exit points, have a one-way flow system. Floor markings are now in place if you go to many retailers. Look at working zones so that you can create cohorts of teams. So you have fixed teams. So the capability of transmission between the staff is reduced, so that, you know, you have your departments, but break those departments into teams so that people are not mixing as much with other people. We all are used to going out, getting some breath of fresh air, getting our lunch outside. You may need to encourage staff to stay on site during working hours to reduce the risk of transmission. Simple things like the canteen, is it going to stay open or closed? Encourage staff to bring their own food in, because if they're going out, then they're mixing with other people, they'll come back into the workplace and the risk of transmission increases. Pop-up wash stations, obviously. Maybe one thing you want to think about is having social distance champions, monitors, people who are there to encourage the staff to maintain the social distance. In the UK, it's 2 meters. In your regulations, it's 1.5 meters. The World Health Organization talks about 1 meter. But whatever it is, having maybe a group of people who are social distance champions may help. Think about having an email system where employees are able to report symptoms, report in. The infrastructure that we have, where you have to go to your manager then contact somebody else, is too slow. So maybe set up a general email where staff are able to let designated individuals know about the fact that they may be not feeling well, they may need to self-isolate, what the symptoms are, so quick decisions can be made. And that's important because you'll need to have records. You need to monitor what's going on within your workplace as far as health is concerned. Also, you need to review what's going on not only within your business, but also in your locality. So someone needs to keep an eye on infection rates within the community. We are told here that we have reached our peak and we're on the downward slope. I understand in South Africa that you haven't reached your peak. The peak may yet to happen. So you need to keep an eye on what's going on locally, nationally, within your workplace. But so people talk about all these different measures that you can take, and as I say, I'm not going to go through them. But what comes through this is that you may need to look at varying your terms and conditions. If you're asking staff to do things in a different way, in different times, changing their shift patterns, changing the hours of work, reducing the interaction they have with others, that may impact on your contractual obligations. So you may need to look at variations to that. Particularly think about your sickness policy. In the UK, we have trigger points that if you take certain amount of sick within a year, there are consequences. So you may need to show some flexibility. You may need to make some changes. Also, as I said, the joined up approach. If you're changing shift patterns, that may have an impact on certain groups. Evidence shows us that women bear the brunt of childcare, and therefore any changes in work hours may mean that there's indirect discrimination on women because of childcare arrangements or other matters. Disability, you may need to take account of the needs of individuals who are disabled. So, next slide. Vulnerable groups. Now, you have a definition in your regulation as to vulnerable groups, and there's a sort of age of 60 is stated there. Why 60? I don't know, but I think don't be misled by thinking that the individuals who are vulnerable only fall in the category that are set out in your regulations. So, for instance, in the UK, disability is far wider than any individual who may be infected with COVID-19. It's broader, and it's the same for South Africa, I'm sure. So listen to concerns, listen to what the unions and the staff representatives are saying, try and create communication with the employees as well. So next slide. Before I go to data protection, I just wanted to touch quickly on what I said earlier, which is you will do the risk assessment, you will have done your preparation, you go to the consultation meetings with various options, you learn from those consultations and refine them. But it's not enough to create an environment. You have to implement the changes, and you have to monitor that. So having signage, obviously you need to think about, should staff be trained? How do we raise awareness? You need to keep records. But also, if people do not comply, are you willing to take disciplinary action? Is that what will be required on your part to ensure that you have a safe system of working? Because there are people who think that, the whole concern about COVID-19 is overdone and it's just like the flu. And therefore, if they do not comply with your rules, are you going to take action? Now, there's a reporting requirement in South Africa, which Feroze may touch upon, and there's no reporting requirement in the UK, and liability rests with if there is occupational exposure on reasonable evidence. So, is there, if someone does contract COVID-19, how are you going to determine whether it was because of what happened in the workplace or outside? And if it is because of what happened in the workplace, then you will have to report that and take action. So it is important that you bear that in mind. So individuals refusing to attend, similar to the South Africa, if employees feel there's serious and imminent danger and have a reasonable belief of that, then they can't be forced to work. And remember, working isn't just the work environment, it's also travel to work. So maybe you need to think about transport. This is where having cycling facilities is mentioned, maybe have carpools, and so your obligations may go beyond the workplace into also traveling to work. As far as data protection is concerned, obviously we will be collecting or looking at collecting data on the health of our staff. How we process that data is going to be important. We have to take measures which are relevant and necessary. We need to ensure that there is an understanding and awareness, and your privacy notices with staff where you say we will monitor X, Y, Z may need to be amended or added to so that it's made clear that you're collecting this information and for what purpose. Can you impose tests? Well, I think the considered view is that like drug and alcohol testing, if it is linked to the job and the nature of the work that's being carried out, testing may be justified, but blanket testing in the UK is not going to be justified. So it will depend on the work. So if you're working in a care home, then or you're dealing with individuals who have are vulnerable, elderly, then you may need to have some kind of test. So, and home working also, you need to ensure that you have systems in place in order to show that there are no data breaches. So the takeaway message is that from the UK, the experience is there are lots of options that you can implement in terms of changing the physical structure. It's about preparation. You need to drill down to your business, look at different areas and see what needs to be done. Identify the risks, create solutions to those risks. Don't go empty-handed when you go to the consultations. You have options. Otherwise, you will be forced into positions that are going to be problematic. Consultation is necessary with staff and obviously with representatives. And communication. You need to communicate what steps you're taking, because confidence is not going to return immediately. It will require you to have a proactive approach and for your staff to know you're taking things seriously, you created a safe work environment, and that action is being taken. And in that way, you will be able to encourage more people to come back and dampen down the concerns that people have. So on that note, I will finish and hand back to Anli. Okay.
For those insights, we are handing over to Feroze to take us through the South African position.
Thank you very much, and thank you for giving me this opportunity of presenting to you people all. I think Makbool has given us a very general and overall picture, has indicated what the problems that each company faces. I think it's an international problem. In South Africa, we have specific directives that have been issued under the overarching legislation which is presently governing our lives. It's the Disaster Management Act, and under the Disaster Management Act, regulations have been passed by the Minister of Cooperative Governance and Traditional Affairs. And pursuant to both the Act and the regulations, the Minister in charge is entitled to require other cabinet ministers under their portfolios to issue different directives. And within the labour environment, the Labour Minister has issued directives pursuant to the Disaster Management Act and the regulations, But it's also important to note that those directions have also their legal source in the Occupational Health and Safety Act. So the particular directions that govern us have been issued under both the Disaster Management Act and its regulations and under the Occupational Health and Safety Act. You may know that presently there's a case in the High Court where the High Court has declared the entire regulations, save for very few which don't apply to workplaces, to be unconstitutional. But the government is appealing that. So until that appeal process happens, those regulations remain binding. And the court also allowed for the level 3 regulations to govern in the interim. So the fact that so currently we're all bound by these directions unless a higher court will rule that all of this is ultra vires or as the High Court found irrational. So these directions are very, very onerous, and it requires employers, specifically larger employers, more than small, but it applies throughout to small and larger employers. I'm going to deal with the general assessment. It requires a number of onerous obligations. So the first onerous obligation there is upon all employers is to create a plan for reopening of workplaces. So what is envisaged here is actually a formal plan that has to be put together under these regulations. And that plan is a plan for reopening of workplaces, and every employer must commence business operations, and this plan must record the risk assessments it's going to undertake, the consult assessment and the plan, the date, time, and opening, the employees who will return or work from home, vulnerable employees, these are employees with pre-existing conditions and employees over 60, workplace protective measures, screening of employees and contractors, and the details of the COVID-19 compliance officer. So you actually have to appoint a compliance officer to monitor this plan. So that's the first obligation, is to create a plan, and it must be in the form, obviously, of a written plan. And if you haven't done that already, you're already in breach of these obligations, because this directives have already been enforced and require this particular plan to be put in place. And as Makbool says, it's best to ensure a very participative approach in ensuring that these plans are put in place. And ultimately, if you have a very unionized environment, I would recommend highly that you involve the unions and you get their consent on the plans for reopening a workplace as a strategic measure to ensure that the majority of workers are at least catered for and proper consultations have taken place. So that's the first obligation that the regulations require, a plan for reopening of a workplace. If you go to the next slide, please. The second obligation that is required is to put in place administrative measures. So there's a general obligation on all employers to undertake a risk assessment to give effect to the minimum measures required by the directive. This applies to small and large employers. So what is envisaged here is actually a proper risk assessment analysis. And then the directive goes on to say that employers that employ more than 500 employees must submit a record of its risk assessment together with a written policy concerning the protection of health and safety of its employees from COVID-19 to the Department of Labor and to the Health and Safety Committee. And this must take place 21 days from the commencement of the direction. So if you haven't done a risk assessment, you need to do a risk assessment immediately. That risk assessment must cover all of the matters under the administrative measures contained in the directive. And one would have to submit that risk assessment to the Health and Safety Committee and to the Department of Employment and Labour within 21 days. The risk assessment requires employers to take special measures to mitigate the risk of COVID-19 for vulnerable employees in accordance with the Department of Health guidelines. It requires the employer to notify all workers of the contents of the directive and the manner in which it intends to implement it. It must notify employees that if they are sick or have symptoms associated with COVID-19, that they must not come to work and take paid sick leave in terms of Section 22 of the BCA. It must appoint a manager as a COVID-19 compliance officer to oversee the implementation of the plan, oversee adherence to the health and safety measures, address employees or workplace representatives' concerns, and to keep them informed. In any workplace in which health and safety committee has been elected, to consult with that committee on the nature of the hazard in that workplace and the measures that need to be taken. It must take measures to minimize contact between workers as well as between workers and members of the public. It must provide workers with information that raises awareness in any form or manner, including where reasonably practicable leaflets and notices placed in conspicuous places in the workplace, informing workers of the dangers of the virus, the manner of the transmission, the measures that the employers are putting into place, social distancing requirements, basically ensuring compliance with these regulations. And then if the worker has been diagnosed with COVID-19, an employer has reporting obligations. It must inform the Department of Health and Department of Employment and Labour of this. It must investigate the mode of exposure, including any control failure, and review its risk assessment to ensure that the necessary controls and PPE requirements are in place. It must determine the need to temporarily close the affected working area. It must give administrative support to any contact tracing measures implemented by Department of Health. So these, if you go to the next slide, these administrative measures are extremely onerous. And as you can see, it requires an implementation of a risk assessment. It requires information sharing with employees. There's reporting requirements. There's a requirement to ensure that a compliance officer is appointed. And these are quite onerous obligations that employers have to undertake. Then the third category that the directive requires is social distancing measures. Every employer must arrange the workplace to ensure minimal contact between workers, and as far as practicable, ensure that there is minimum of 1.5 meters between workers while they are working, for example, at their workstations. So there's an entire section on social distancing measures that requires the employer to ensure compliance with. Among it is also arrange physical barriers to be placed between workstations, and when required, supply employees free of charge with appropriate personal protective equipment based on a risk assessment of the working area. And every employer must ensure that social distancing measures are implemented through supervision, both in the workplace and in the common areas outside the immediate workplace through queue control or within the workplace, such as canteens and lavatories. So again, this social distancing measure applies to both inside and outside the workplace, and they are extremely onerous again. Okay, if you go to the next slide, please. Then the third category is health and safety measures that the employer must put in place, and obviously all of this will be in your risk assessment plan, and some of them specifically mentioned are symptom screening, sanitizers, disinfectants, and other measures, clothes, masks, measures in respect of workplaces to which public have access, ventilation, personal protective equipment. So again, there's an entire section that one would have to ensure compliance with regard to the social distancing measures, and your compliance officer would have to monitor all of these. Some of them are quite onerous. I've just given a high-level summary, but I'll urge you to obviously look at the directive more closely because each one of these measures are regulated. There's also measures in respect of workplaces to which public have access, and there's specific regulation dealing with this particular, a directive dealing with this. All of these on the screen have specific subsections governing them. So like ventilation is an entire section on what must be ensured in terms of ensuring proper ventilation. For example, keep the workplace well ventilated by natural or mechanical means where reasonably practicable, have an effective local extraction ventilation system, ensure that filters are cleaned and replaced in accordance with the manufacturer's instruction by a competent person. Again, extremely onerous obligations placed on employers. Then there's also specific obligations on employers with less than 10 employees. I won't deal with that, but overall, you need a risk assessment plan. And then there's also workers' obligations. Workers are all bound to ensure compliance with this under the Occupational Health and Safety Act. And every worker is obliged to comply with measures introduced by the employers as required by the direction. You can imagine that this is going to create a number of problems for employers, because you now have to realign your workplace, as Makbool say, consider your terms and conditions. Some employees will not be allowed to work. You're going to have issues about who's entitled to payment, who's not entitled to payment. Those become very complex issues. In the hard lockdown phase, it was a bit easier because employees were prevented from tendering their services. But in the soft lockdown phase, a level 3 where we are, it's not really soft, but I mean, it's a lesser level. Employees are not under a strict obligation not to tender their services. They're not prevented from doing so. It's for the employer to determine which employees should come to work, which not. And then one is going to be faced with this question: who is entitled to payment, who is not entitled to payment? How do you restructure the workplace? Must you act fairly? Can you only favor certain workers who are allowed to work and others not? And you can have unfair labor practice challenges coming from that. You can have discrimination challenges coming from that. So that's quite a very complex part of the compliance with these directives. Then the other additional question is the refusal to work due to exposure to COVID-19. So there's an entire section in the directive which starts off by saying an employee may refuse to perform any work if circumstances arises with which reasonable justification appear to that employee or health and safety representative to pose an imminent and serious risk of the exposure to COVID-19. So it's a subjective test, but there must be an objective basis for the subjective belief. And the particular section that deals with this says that no person may threaten to take any action against a person because that person has exercised or intends to exercise the right in terms of clause 48. No person may advantage or promise to advantage any person for not exercising his or her right in terms of clause 48. No employee may be dismissed, disciplined, prejudiced, or harassed for refusing to perform any work as contemplated in clause 48. And if there's a dispute in terms of this, that dispute, an employee may refer that to the CCMA or to the bargaining council, and that dispute can, after conciliation, be arbitrated. So we have an entire new dispute resolution section dealing specifically with cases of employees who do not want to come to work. I can just add that there's an additional element to this. So you may find an employee who does not have a reasonable basis for not wanting to come to work, but subjectively is so paralyzed by this virus that an employee believes, even irrationally, even after all safety measures have been put in place, that employee can't come to work is going to expose himself or herself. So there's case law to the effect that becomes an incapacity problem, not really a misconduct problem. So even in cases where employees refuse to come to work, and I think it's going to be very hard to tell an employee you don't have a reasonable basis in this environment. It's going to be extremely difficult because employees need to travel to work and there's all sorts of risks that they're exposed. But if you find yourself in a situation where you believe as an employer that an employee is actually being unreasonable, it's not necessarily so that a disciplinary process is the proper process. One has to check the bona fides of that belief. And if the belief is bona fide but still unreasonable, discipline may not be the option. So this creates an entire new regime for employers. It has always existed in the mining industry, this requirement, but this is now a general obligation. Okay, the next slide. This is now a complicated question. What if one employee knows that another employee has the illness? Is the employee with knowledge obliged to disclose that to the employer? And the short answer is yes. I believe that that employee would be obliged to disclose that, and the reasons are threefold. One is in terms of the COVID regulations, which places obligations on everybody, and places obligations on and actually criminalizes intentionally exposing other people to the virus, and people may be prosecuted. So if you have knowledge and you don't go forward, and somebody contracts the illness and you didn't come forward, you're possibly vulnerable to a criminal prosecution. So on the COVID regulations, I believe there is an obligation to disclose. If you go to the next slide, then you'll also see that if you go to the next slide, please. The Occupational Health and Safety Act, that places obligations not only on employers but on every employee to take reasonable care for the health and safety of other employees. So the Occupational Health and Safety Act applies to all employees in the individual capacity, and that will also create the obligation to report. So I believe that employees who have knowledge that their co-workers are living with this virus now would have a duty to report this to others, and it would not be a breach of privacy obligations. We have the Protection of Personal Information Act, but I believe it's not yet enforced. But that also has created certain exceptions, and one of them is disclosure for medical reasons. And that would be another reason why I believe there is such an obligation on individual employees to disclose the health of other employees, particularly in this particular environment. We know with HIV, for example, there's cases which prohibit disclosure because of confidentiality, but I do not believe in this instance that confidentiality would protect somebody or be a basis for not disclosing, disclosing that somebody is living with this virus. Thank you very much. You can see from this it's quite onerous, and I would advise employers to study this directive very carefully and ensure that they comply with it. As a concluding remark, the failure to comply with this directive, because it's also published under the Occupational Health and Safety Act, there are criminal offences under the Occupational Health and Safety Act in terms of that act, and so employers will be advised to look at Section 38 of the Occupational Health and Safety Act and ensure proper compliance with this directive. Thank you very much.
Thank you, Feroze, for that expose of the South African regulations. I just wanted to talk about the refusal to work. I think that obviously is a difficult situation that many employers will have to deal with. But this is why I've said that it is important that we create the right environment before we get to that situation. And I think, as you've pointed out, there may be employees who have this genuine but mistaken belief that not enough has been done. And it's, as you say, a subjective and objective test. And I think the courts will be more sympathetic to employers in assessing whether the belief is reasonable if the employer has taken all the steps that we've said, which is to plan, create that plan, make it specific to their workplace, and raise awareness, create that training, maybe, as I say, have those social distance champions, put all the measures in place, which are specific. I repeat, I don't think it is wise to adopt a template approach, look at what others are doing and necessarily copy them. You have to address your mind to your own work environment and what needs to happen in that environment. Set it out, record it, so there's a paper trail. So if there is litigation, then you are able to show that you have taken all necessary steps as are reasonably practicable to create that safe working environment. And another important point which I raised earlier, which is you've created the environment, but you have to be seen to be enforcing it. There will be exceptions. There will be people who will not comply with the rules. They always are. And therefore, it is important to ensure that we are seen to be taking action. That may be disciplinary action or whatever, but we must be seen to be enforcing the plan and the kind of rules that we have put in place. That's our job. That's what HR need to do. And we need to make it clear to employees that these are not sort of preferences or likes. We will implement them, we will impose them, and action will follow if they're not followed, because it's our responsibility to create that safe working environment. So, as I say, it's not enough just saying it, we have to do it. Not only we have to walk the talk. As far as disclosure is concerned, that's another tricky issue. If someone within the workplace contracts COVID-19, how much information are we obliged to disclose? In the UK, obviously it will be very fact specific, but the view is that it would be taking a step too far, unless justified in the circumstances, to disclose the identity of the individual. But obviously, as an employer, you've got reporting requirements in South Africa to the Department of Labour. You need to find out, how did this individual contract the virus, whether it was in the work environment or not. And that will mean speaking to others who maybe have been around this individual in order to find out how much contact they have had. I personally, at this moment in time, take the view that revealing the identity of the individual may be going a step too far, but it will depend on the specific circumstances. In certain circumstances, it may be necessary. Let's see what happens with the technology. There may be apps created in order to find out how much contact you've had with someone else. That may arise. There are difficult issues here, but I am confident that with the right approach, you can, you can get over the difficulties and create the right kind of environment. But unlike the past, this means there needs to be a partnership between all the different functions within the business, the legal, HR, and the communication. And communication is important. It's about confidence, building confidence. And that confidence can only be built if we are transparent and we communicate that. So make use of all the facilities you have, the signage, the intranet, the website, be open, make people feel safe. That's what it's about. It's about ensuring that there is people feel comfortable in returning, and that's how you will be able to do it. And there are no easy solutions. Unfortunately, it's hard work. And as I say, please avoid the temptation of cutting and pasting some template that you find on a website and thinking that's going to work. It's not, because it has to be about your work environment, your situation, your risks, the work that you've done and your records, and that is what's going to get us through. Sorry, thank you.
Thank you, Makbool and Advocate Boda. Just to conclude then, there is another aspect that needs to be considered by South African employers and especially HR practitioners as well, and that is the temporary employee relief scheme. We have seen an increase in fraud in the United Kingdom in the use of the furlough scheme, and I think there's valuable takeaways from that as well. In South Africa specifically, the directive regulating the TERS scheme, as well as the memorandum of agreement, which is sent to most employers to sign, sets out quite specifically that TERS funds may only be used for employees on behalf of who a claim has been submitted. So as you'll know, the TERS fund is the relief fund that you can submit a claim if there's been a partial or complete closure of your business. We just take this opportunity to also remind our clients and everyone else attending this webinar that there are specific audit requirements in terms of the Memorandum of Agreement, and that you must have a very secure audit trail or paper trail, which the Department of Unemployment Insurance Fund can visit your premises at any point to inspect, and you need to give them access to that information. For that reason, it's worthwhile getting your accountants involved to just ensure that the accurate paper trail is there should any questions arise. Over and above the TERS scheme, we just conclude by stating a few takeaways from this webinar. The first is that you must do your workplace risk assessment with specific reference to your workplace. Although there is a template assessment being issued by the Department of Employment and Labour, it's worthwhile tailor-making that assessment for your specific workplace and then feeding that into your workplace plan. Keep in mind that your employees remain concerned. From a mental health perspective as well, employees are suffering, and for that reason it really is worthwhile involving them in the process from the start. Streamline your communications with quick reactions, perhaps have a specific person who they can interact with or a specific email address who they can send their queries to. And most importantly, review your policies, procedures and contracts of employment to identify any possible changes that would need to be made. That then brings us to the end of the webinar, and we thank you for joining us today. If you have any specific queries that you'd like addressed or any other advice that you may need, please do use the email address from which this invitation was sent.